Distinguished delegates, ladies and gentlemen, welcome to our last day of deliberations. The Commission adopted the agenda for this session on 23rd June 2022, including today's virtual panel discussion on sharing experience across regions, insolvency reforms in Latin America, Europe and beyond. I am delighted to welcome the participation of states using Uncetral texts and partner organizations in Uncetral technical assistance and cooperation activities to today's session. The Commission may recall that since 2018, the Secretariat has organized panel discussions on technical assistance activities to inform the Commission on the use of Uncetral texts by states and key stakeholders at a global level. Previous panels featured MSME's recovery, COVID-19 response and recovery, legal transformation in developing and transition countries, and the role of international development assistance in implementing sound reforms in international trade law. Our panel discussion this year focuses on insolvency and celebrates the 25th anniversary of the Uncetral model law on cross-border insolvency. It also celebrates the success of that text. The model law has been enacted in 55 jurisdictions to date, together with or followed by Uncetral's other instruments on insolvency law. Together, these texts offer a toolbox covering most aspects of a strong and effective insolvency framework. Uncetral's Working Group 5, through its two current projects on asset tracing and recovery and applicable law in insolvency proceedings, is continuously working on refining the tools for the benefit of states, courts and practitioners. This morning we will hear from participants about the role that Uncetral insolvency texts and capacity-building initiatives have placed in recent interregional and multilingual assessment exercises and knowledge-sharing activities in the area of insolvency law, and the benefits of the multilingual and cross-regional approach evolved. Before we start, I would like to give the floor to Madam Secretary concerning some housekeeping notes. Madam Secretary, you have the floor.
Thank you, Chair. Good morning to all who are joining us online and to those who are joining us in person in the room. Please allow me to give you a bit of information regarding the panel. This panel will be held under a hybrid format that requires some adaptation to our working methods. Since we are convening under the hybrid format, this session will be slightly shorter than usual, 2 hours instead of 3, to accommodate simultaneous interpretation being provided in an online setting. For participants online, they may choose the audio language by clicking on the icon Interpretation at the bottom of their Zoom screen. Due to time constraints, there will be no live Q&A at the end of the panel. However, delegates participating in the room are welcome to make any comments or query they wish to make directly to a representative of the Secretariat sitting next to me on the podium. For online participants, it is also possible to do so using the Q&A function of the Zoom platform in the 6 official UN languages. In both cases, in person or virtually, the Secretariat will provide an answer as soon as possible, that is after today's session. Finally, the meeting will be recorded by the Conference Service of the United Nations. Video and audio recordings will be made available on the Uncetral website in the 6 official languages of the United Nations, and a report will be shared with Working Group 5. This broader dissemination of the work of Uncetral on insolvency is designed to allow its lessons to reach a wide audience. And with this, I now pass the floor to Madame Samira Musayeva, Senior Legal Officer in the International Trade Law Division and Working Group 5 Secretary, to introduce the first panel of the session. Samira, you have the floor.
Thank you. The focus of the first session is on the diagnostic tools on which the Uncetral Secretariat relied in the preceding reporting year to inform itself about experience with the use of Uncetral insolvency texts, needs for insolvency law reform, capacity building in that area, and cross-border dialogue on insolvency matters. The role of those tools is twofold. First, they by themselves help to promote Uncetral insolvency texts, since the tools that will be presented during the session used or referred to Uncetral insolvency text as a benchmark for insolvency law reform. Second, they inform the Uncetral Secretariat about the experience with the use of Uncetral insolvency texts and gaps in insolvency law reform and capacity building needs in this area of law. That knowledge is essential for the Uncetral Secretariat to devise targeted, effective, and efficient technical assistance activities, in particular by connecting related programs and areas of work of the Uncetral Secretariat and its partners, which in turn leverages limited resources available in the Uncetral Secretariat for non-legislative activities. The session brings together long-standing and new partners of the Uncetral Secretariat who will present top-down and bottom-up approaches to the assessment of the state of insolvency law and its implementation across the globe. This mixture is healthy and helpful since it expands our outreach, diversifies our perspectives and programs, and leads to balanced and inclusive outcomes. The first two presentations are from the World Bank Group and International Monetary Fund. Andres Federico Martinez, Senior Financial Sector Specialist from the World Bank Group, and Jose Garrido, Senior Counsel, International Monetary Fund, are well placed to present assessment methodologies used by those institutions in the area of insolvency law, since they have long experience with performing those assessments themselves. Mr. Martinez, Mr. Garrido, tell us about those methodologies and the role that Uncetral insolvency texts play in that context.
Thanks, Samira, for the kind introduction. And thanks to Uncetral for the invitation to the World Bank to present its methodology when conducting the insolvency assessments. The work of the World Bank Group in the field of insolvency and creditor-debtor regimes, I will call it ICR from now onwards, focuses on four major areas. The first one is standard setting. The World Bank Group and Uncetral together are co-standard setting institutions in the ICR area. ICR systems constitute a crucial part of the legal infrastructure to promote a stronger investment climate and to enable market participants to more accurately assess, manage, and resolve default risks in commercial relationships, contributing to economic development, job preservation, and financial stability. In 2001, the World Bank developed the principles for effective insolvency and creditor-debtor regimes, so the World Bank principles, or the principles I will call it now, which since then have been updated several times. The last updated version was published in April last year. I believe this document will be shared, or the link will be shared by the Secretariat in the chat. Both the World Bank principles and the Uncetral legislative guide on insolvency law distill international best practice on design of ICR systems, emphasizing contextual, integrated solutions and the policy choices involved in developing those solutions. The principles, combined with the recommendations contained in the Uncetral legislative guide, form the ICR international standard, recognized as such by the Financial Stability Board. Which leads me to the second point, which is the assessments that the World Bank conducts. The World Bank Group engages in the implementation of the ICR standards through its diagnostic assessments, which cover all aspects of the life cycle of credit in four primary areas: creditor-debtor regime rights systems, credit protection, secure transactions, registries, enforcement procedures. That's number one. Number two, risk management and recovery system, which is comprehensive of credit information, director and officer liability with respect to financially distressed businesses, and informal debt restructuring practices and workouts. Number three, the formal insolvency proceedings, which include liquidation and organization. And finally, last but not least, institutional framework for ICR implementation. This is courts, insolvency representatives. The ICR assessments analyze both the law on the books as well as its implementation. The methodology is based on the international standard. A country's insolvency framework is evaluated against the benchmark of the World Bank principles and the recommendations contained in the Uncetral legislative guide on insolvency. The assessment process is initiated distributing questionnaires to local authorities and stakeholders. The ICR team gathers and reviews legislation and as much data as is available. And then a field mission provides insight into the practical application of the insolvency framework. This is critical. Meeting and interviewing with banks, local law firms, insolvency administrators, judges, accounting and auditing firms, registries, all sorts of government agencies, etc. After that exhaustive information gathering process, the overall findings and recommendations of the ICR team are materialized either in a ROSC, which is a report on the there's some background noise. Sorry, I don't know if okay, now it's gone. A ROSC, which is a report on the observance of standards and codes, or a much shorter technical note. Both instruments, the ROSCs and the technical notes, are similar in coverage, although sometimes the technical notes are, due to their much shorter nature, may focus on certain more limited aspects of the standard at the request of those who lead the broader financial sector exercise. So basically, the difference is in the length. ROSC include a principle by principle annex with a detailed description and rating of the country ICR framework, and that annex is not included in the technical notes. But both assessment documents are aimed at identifying the weaknesses and areas for improvement in a country's ICR system, offering recommendations for improvement, and offering some sort of implementation guides. So these are contained in both documents, right? And after the delivery, of course, the ICR team remains available to discuss the recommendations with the counterparts. That leads me to the third aspect of focus, which is the technical assistance. I will very briefly mention this, which is by agreement with country authorities. Sometimes the World Bank Group assists on legislative, judicial, and regulatory reforms as needed, or specialized judicial training programs, or longer-term assistance for capacity building to professionals involved in ICR area. And this is where it's critical. The Uncetral legislative guide on insolvency law is the main reference piece for providing technical assistance for legal reform and specialized training. Also, as regards the Uncetral model law on cross-border insolvency, its enactment has always been recommended to fully comply with the ICR standard on international aspects of insolvency proceedings. In many cases, such recommendation resulted in the adoption of the model. Finally, knowledge sharing. The World Bank Group engages in knowledge sharing through a number of outreach initiatives that seek to generate public awareness of the World Bank work in this area and the importance of insolvency law reform. Some examples are the Toolkit for Corporate Workouts, which I believe the Secretariat will share in the chat, and many other notes published in our website. And Uncetral, again, is a key institutional partner of the World Bank Group in this field too. For example, I'm going to cite one example. There's many. Both institutions jointly organize, together with International and International Judicial Colloquium on Insolvency, which brings together judges from the developed and developing worlds to discuss areas of common concern in handling insolvency cases. Last but not least, I wanted to mention there is a pre-concept note currently under discussion in the World Bank, which sits outside of our team's scope, but it is called preliminarily BEE, Business Enabling Environment. That is a set of indicators that intends to improve on some of the areas formerly covered by the doing business indicators that were phased out. The idea, again, this is not finalized, it's that it includes 3 pillars. One of them will benchmark the quality of insolvency regulations, the other one, the operational infrastructure of insolvency proceedings, and finally, measure the efficiency, meaning the time and cost of the insolvency framework. Given that the methodology does not have final approval yet, I'm afraid I cannot give you more details on this, other than the ones listed in the public website, which I believe the Secretariat will join. With that, let me finish, and not before congratulating Uncetral again on the occasion of the 25th anniversary of the Uncetral model law on cross-border insolvency. With that, let me pass it to José Garrido from the IMF. José, the floor is yours.
Thank you so much. It's both a pleasure and an honor to be able to participate in this panel discussion to provide an overview of the experience of the IMF in the assessment of insolvency systems. The key functions of the IMF are the surveillance of the international monetary system, the monitoring of members' economic and financial policies, provision of fund financing to member countries to address their balance of payments problems, and the delivery of technical assistance and financial services. Surveillance of the economic health of member countries and of developments that create risks to economic growth and financial stability can require the analysis of the national insolvency regime. In fact, sound insolvency regimes are crucial for economic growth, financial stability, and for delivering an adequate response in the event of an economic crisis. I will briefly speak about the methodology we use for assessments, how we design and use indicators, and how we aim at integrating empirical data in insolvency analysis. For the assessment of insolvency systems, we use the methodology developed in accordance with the International Insolvency Standard. Assessments of insolvency systems can be conducted in the context of surveillance, so-called Article 4 consultations, in the context of broader financial sector assessments, FSAPs, or as part of technical assistance requested by national authorities. As indicated before, the Insolvency and Creditor Rights Standard is composed of the World Bank principles and recommendations from the Uncetral legislative guide on insolvency law, and has been compiled by both organizations in consultation with the IMF. The standard is broad, with a strong emphasis on insolvency law, but includes also other important elements in the protection of creditor rights. As an assessment tool, it is extremely useful to identify issues and help countries improve their insolvency regimes. The methodology was developed by the World Bank and Uncetral on the basis of the standard with the assistance of the IMF. The latest version is from 2011, and it includes 285 criteria for assessing compliance. The methodology is very detailed, and it sets out all the essential criteria that need to be taken into account by assessors. It focuses mainly on specific features of insolvency law, including liquidation, reorganization, cross-border insolvency, and institutional aspects. And the analysis focuses not only on the law, there is also room for how the legal provisions are applied in practice. Many of the assessment criteria come from the recommendations in the legislative guide, since the principles tend to be high level. In this way, the solutions included in the guide are extremely useful and provide the backbone for the assessment of insolvency systems. Let me turn now to the use of indicators. The IMF puts a strong emphasis on economic research. At the intersection between the law and the economy, there are many promising lines of analysis, including research I don't know where the sound comes from. Okay, it's gone. Thank you. Including research on the economic effects of insolvency law. There is abundant economic research that makes use of indicators that refer to legal or institutional characteristics to assess their interaction with the economy. In 2018, the IMF issued a guidance note for the use of third-party indicators in fund reports. Essentially, indicators created by third parties can be used, but IMF staff need to understand them, including its methodology and its limitations. For this reason, there is a preference for using indicators created by the fund itself. We have designed 2 indicators for research connected with insolvency regimes. In 2020, we published a working paper on the prevention and treatment of over-indebtedness in Asia, which included an indicator measuring various aspects of the legal regime for enterprise and personal insolvency. This allowed the economists to test several hypotheses about the relation between the law and the economy. Then, more recently, in February 2022, we designed another indicator to measure the degree in which legal systems could be prepared to face a corporate debt crisis. This crisis preparedness indicator is built with elements from the standard that we have found to be especially useful in cases of crisis. Our indicators are based on core elements of the insolvency standard, although they may extend further than the standard or emphasize certain aspects of it. We believe that these indicators perform a useful function in supporting economic research and delivering an interdisciplinary message. However, indicators are just indicators. They merely point to the possible existence of issues and always require further analysis. So they are considered more a research tool than an assessment tool. In addition, we do not use rankings as we believe their negative aspects outweigh any positive effects they might have. Finally, let me just say a few words about empirical data. We are firm believers in the use of empirical data. This has been the traditional position of economists, but we also believe that this is the future for the law. A lot of the disputes and controversies in the design of insolvency laws are based on opposing ideologies or maybe opposing prejudices, but there is a scarce empirical evidence to support positions in favor or against any given solution. We provided some indications on how to use data in assessing and designing insolvency systems in a working paper published in 2019. Granular statistics allow making accurate judgments of what works and what doesn't work in a legal system. Insolvency systems need to perform effectively crucial economic functions, and ultimately, the most reliable assessment of their performance will be based on actual data. Thank you.
Thank you for sharing your hands-on experience with the assessment of insolvency law frameworks in countries in which the World Bank Group and the International Monetary Fund operate. As we heard, Uncetral insolvency texts have long been used as a best practice benchmark in the assessments performed by those institutions for various purposes related to the core mandates. We hope that they continue being used, including in the Business Enabling Environment project, the success of the Doing Business report and data, and that cross-border insolvency aspects would not be overlooked. In that context, it should be recalled that the Uncetral Legislative Guide on Insolvency Law, whose recommendations are part of the insolvency standard, includes recommendation 5 that recommends states to enact the model law on cross-border insolvency. The next presentation is by Ms. Catherine Bridget-Sola, Senior Counsel in the Legal Transition Team of the European Bank for Reconstruction and Development. The Uncetral Secretariat has long experience with the Legal Transition Team in Ebrd. In 2021, Ebrd launched a new tool for assessing business reorganizations frameworks in Ebrd countries of operations, to which the Uncetral Secretariat had a chance to contribute. The outcomes of the first assessment became ready in February this year. They turned out to be very informative for the Uncetral Secretariat and led to the plans for future cooperation with Ebrd in the area of insolvency law. Ms. Bridget-Sola, please tell us more about the first assessment and future plans.
Thank you very much, Samira. Ladies and gentlemen and distinguished delegates, I'm delighted to participate in today's event on behalf of the European Bank for Reconstruction and Development. I would also like to congratulate Uncetral on the 25th anniversary of the model law and its work so far on harmonization of insolvency systems. As mentioned, I will provide a brief overview of the EBRD assessment work and future activities in the insolvency sphere. First, I'd like to say a few words about the EBRD's Legal Transition Program. This is our program which aims to establish laws, regulations, and institutions that support the development of a strong investment climate in the countries where the EBRD operates. We regularly carry out legal assessments which benchmark national legal frameworks against leading international practices, such as in the area of insolvency. And this is important for us because it helps us to identify gaps in those frameworks and also the countries where we should be prioritizing our efforts. So in February, we published our assessment report on national legal procedures that support the restructuring of businesses that are either insolvent or in financial difficulties. We covered 40 jurisdictions where the EBRD invests, including Central Asia, Eastern, Central and Southeastern Europe, and North Africa. Our assessment and the methodology that underpins it are closely aligned with the Uncetral Legislative Guide on Insolvency, with the World Bank standards, and also with the recent EU directive on preventive restructuring. Like Uncetral, we underscore the importance of having expedited reorganization procedures for debtors that are not yet insolvent, protection for post-commencement financing, which is critical for reorganization, and protection of essential contracts for the debtor's business, which help to ensure the business's ongoing operations. We also consider the availability of cross-border insolvency provisions, which are important for successful business reorganization across borders, as well as trade and the attraction of external investment. We rank economies in our assessment in terms of the overall strength of their business rescue framework. And our ranking is determined by a mixture of an assessment of law on the books, as well as feedback from market participants. So for this assessment, we collected feedback from over 500 people within the EBRD regions who work regularly with insolvency. Our final ranking included a bonus score, which we allocated to countries that publish comprehensive and clear insolvency data. We also measure countries' performance by certain benchmarks. These are efficiency, effectiveness, and flexibility. Our efficiency benchmark is closely aligned with Principle 5 on timely and efficient resolution of insolvency in the Uncetral Guide, while also incorporating economic efficiency. The effectiveness benchmark reflects the general desire for sufficient reorganization tools and national frameworks, such as intra and cross-class creditor cram-down. Finally, the flexibility benchmark measures procedural and legislative flexibility, including whether there are one or more available procedures, hybrid procedures, and simplified procedures for small enterprises. All of the materials from our assessment, the 40 economic profiles, economic and jurisdictional profiles, the 20 annexes with detailed comparative information and data, as well as the data from the questionnaires, are available on the EBRD's website, ebrd-restructuring.com. I will now briefly highlight 3 important findings from the assessment, which will help to shape the EBRD's future activities in the insolvency sphere, and we hope also our cooperation with Uncetral. The first finding is that more work is needed to improve legal procedures for business reorganization in many jurisdictions. There is a lack in some jurisdictions of accelerated or hybrid reorganization procedures, which are very important, as you all know, for value preservation and a swift exit from insolvency. And these were only available in half of the countries that we assessed. Equally important is protection for new financing or post-commencement financing, and 15 of the countries that we assessed did not have any specific protection for that in their national legislation. Third, it's also important for there to be some protection against contractual termination for essential contracts, and at least one reorganization procedure. But this was missing in the majority of jurisdictions, so 20 overall. A second finding, which the assessment highlighted, is the potential for even greater adoption of the successful Uncetral model law on cross-border insolvency and related text. While coordination amongst jurisdictions and better administration of cross-border insolvency proceedings is essential for trade, 23 of the countries where the EBRD invests do not have any provisions yet for cross-border insolvency in their national insolvency legislation. And officially, the Uncetral model law has only been implemented substantially implemented in 6 of the economies where we invest. However, it is interesting to see that there is, unofficially at least, a lot of influence of the model law in 9 other jurisdictions. The third finding I'd like to highlight today is the absence in the vast majority of countries of provisions that are tailored for micro, small, and medium-sized enterprises. According to our assessment, only 3 EBRD economies have adopted specific provisions based on the company's size for reorganization, business reorganization type procedures. So I think there's a lot more to be done on the policy front to encourage national legislatures to think about micro and small enterprises now that we have Uncetral's recommendations and guidance on the subject. There are, of course, many other important findings from the assessment, and too little time to mention, but these include the need for greater specialization among insolvency judges or among judges in many jurisdictions. So in half of the jurisdictions that we covered, insolvency cases are administered by general courts of civil jurisdiction, and there does not appear to be the requisite specialization. Finally, I would just like to highlight our next steps as an institution in the policy sphere. As the IMF speaker alluded to, there is a dearth of data around insolvency. And our goal at the EBRD is to work more closely with national authorities to improve the availability of insolvency data. This was a key issue that emerged during the assessment, and we found that only 5 of the countries that we covered have comprehensive, up-to-date insolvency registers. In 10 of the countries, there was no publication of insolvency data whatsoever. So there's clearly work to be done in raising capacity in this area and in improving more data-driven insolvency decision-making. And as part of our emphasis on gathering this data, we will be working closely with Uncetral to understand better the use of the model law on cross-border insolvency, and also just to raise awareness of its benefits and the need for cross-border insolvency provisions. We will also continue to monitor developments on the micro and smaller sized company front because we expect these to be very relevant for future insolvency law reform. Thank you very much for giving me the opportunity to take the floor, and congratulations again on all the invaluable work that Uncetral has done in the insolvency field.
Thank you. Ebrd tool is a newborn in comparison with the methodologies used by the World Bank and the International Monetary Fund. We are glad that it also solidly builds on Uncetral insolvency text. We are also happy that there are plans to expand indicators in the Ebrd assessment methodology related to a simplified insolvency regime for micro and small enterprises, and also for cross-border insolvency. Uncetral Secretariat stands ready to assist and benefit from future assessments results, as we did from the first one. The previous three speakers represent the top-down, donor-driven assessments. The bottom-up, grassrooted assessments are equally important and informative for the Uncetral Secretariat. The next two speakers will talk about them. First, Mr. Andre Rocha from the Ibero-American Institute of Bankruptcy Law, an observer organization invited to Uncetral Working Group 5 sessions. Among his other positions, Mr. Rocha is International Academic Coordinator at the Brazilian Insolvency Institute. These two institutions launched last autumn the Latin Euro-American G8 Insolvency and Restructuring Program. The Uncetral Secretariat didn't hesitate to support the program. After Mr. Rocha's presentation, it should be clear why. Mr. Rocha, please. We cannot hear you at all, unfortunately.
Hello, will you hear me?
Yes.
Okay. Sorry. Distinguished delegates and observers, thank you for the opportunity to present the G8 Euro-American Insolvency and Restructuring Program to the Commission. The concept behind the program emerged from the perception that we, as Latin countries, are always looking at Anglo-Saxon common law insolvency systems as the models to be followed. They have a lot to teach us as developed countries, and we have much to learn from them. But as an organizer of the program, I thought that was about time for us to start looking at ourselves and learning from each other. After all, we have the same cultural roots, and we are all civil law jurisdictions. So we have created a program with that purpose, the exchange of experiences and knowledge between the main Latin economies. In America, Brazil, Mexico, Colombia, and Chile, and in Europe, France, Italy, Spain, and Portugal. 2 continents, 8 countries. This is how G8 Euro-American was born. It was run during 8 weeks, 1 week per country, 2 days of sessions, 3 hours each. On day 1, the session involved presentation and discussion of countries' insolvency system and legal framework analyzed from the perspective of the Uncetral legislative guide on insolvency law. A more legal, theoretical, and academic approach was taken in that analysis. On day 2, the session involved presentation and discussion of an iconic cross-border insolvency case of each country covered by the program, from the perspective of the Uncetral model law on cross-border insolvency. A more practical approach was taken in the analysis on those cases. Each session was held in the language of the jurisdiction covered, Spanish, French, and Portuguese. In each of the G8 jurisdictions, the project was led by a local leader, experienced, respected, and well-known professional in the insolvency sector. The selected G8 leaders were myself, Andre Rocha, Brazil, Luis Palomino, Mexico, Francisco Reis Villamizar, Colombia, Juan Luis Goldenberg, Chile, Natalie Laboche, France, Luciano Panzani, Italy, and José Pajares in Spain. And also Teresa Pitorra in Portugal. They in return selected local experts to speak about countries' insolvency system on day 1 and professions who were somehow involved in the cross-border insolvency cases to speak on day 2. The selected leading cases related to Uncetral model law and cross-border insolvency were in Latin America, Oi Telecom in Brazil, Oro Negro and Aeromexico in Mexico, Avianca in Colombia, and Latam Airlines in Chile. The selected leading case in Europe, as related to European Union cross-border insolvency proceedings, were CGG in France, Parmalat and Alitalia in Italy, Abengoa and Delphi in Spain, and Rio Forte, a holding of Banco Espírito Santo in Portugal. We've also invited Portuguese, Spanish, French, and Italian-speaking countries to participate, as the G8 group has a great potential to influence positively these jurisdictions' insolvency systems by sharing great knowledge and professional experience. The institutions that agreed to sponsor the project from its inceptions were Ebrd, the Brazilian Insolvency Institute, and IIDC, Instituto Ibero-Americano de Derecho Concursal. After its inception, the project was presented to the Uncetral Secretariat, which fortunately became an official supporter. I thank you so much, Uncetral Secretariat, for opening its doors to the G8 initiative, which provided a much higher stature to the project, indeed. Also, Insol International joined as official supporter. With Uncetral on board, 19 international experts by Uncetral Secretariat were appointed to analyze and comment each of the G8's session. So after 8 weeks, we successfully finished the G8 48 hours marathon that involved the top 8 Latin economies in the world, total of 66 professionals, 8 local leaders, 8 entities representatives, such as the president and CEO of Insol International, the president and vice president of IIDC, besides Uncetral legal officers. 19 Uncetral international experts, 32 local speakers, and more than 300 participants enrolled. 8 insolvency systems presented and discussed. 11 leading cross-border insolvency cases presented and discussed. After the 16 days of G8's country sessions, it was a time to analyze and discuss the best moments of the race. 2 days of the roundtables between the G8 leaders and Uncetral legal officers and experts took place in March this year. Those were days 17 and 18 of the program that brought together the Uncetral legal officers and 5 appointed experts joining the G8 leaders on the roundtables. The Uncetral experts were Jean-Luc Valens in France, Lucio Guia in Italy, Luis Mehan from Mexico, Diana Rivera from Colombia, and Thomas Felsberg from Brazil. During those 2 days, best practice and bottlenecks of each systems and its insolvency cross-border application were discussed, and how each system and practical experience can be contributed to improve one another. The final step was the preparation of a final report signed by the G8 leaders. 100 pages final report was signed by the G8 leaders, containing a summary of the main points analyzed and discussed during the program. This report was sent to Uncetral Secretariat, on which basis it reported the main findings to the Commission at this session. We hope that the report will be the valuable source of information for future reference and used by the Uncetral Secretariat in designing its capacity building and other promotional activities in the region and across regions in the area of insolvency law. We're also glad to note that the network established through the program and discussions held have turned out helpful to the Uncetral Secretariat, in particular for expanding its database of cases related to the 1997 model law, which 25th anniversary celebrated this year. We are also glad to hear from the Uncetral Secretariat that the multilingual and cross-continent concept of the program that brought together 8 civil law jurisdictions in the dialogue on insolvency matters may be replicated in other programs of the Uncetral Secretariat. We look forward to our further cooperation with Uncetral Secretariat and the G8 initiative. Thank you very much.
Thank you. Indeed, the program stands out for its cross-continental outreach, its multilingualism, its focus on continuous dialogue on insolvency issues among civil law jurisdictions and between EU and non-EU countries, and its action and result-oriented approach aimed at increasing visibility across the world of important insolvency-related developments in Latin America. We are happy that those developments concern among others, the enactment and use of the model law on cross-border insolvency and the Uncetral legislative guide on insolvency law. The program produced much impact on our legislative activities that we reported to the Commission this session. We hope that the cross-border insolvency dialogue initiated by the G8 program would continue. Our continued engagement in the program promises to lead to many interesting joint projects that would help us to promote the understanding and use of Uncetral insolvency text, including the newly adopted ones. For example, the Latin American and Caribbean days this year will include micro and small enterprise insolvency aspects. There is increased interest in enterprise group insolvency in the region, which may lead to enactment of the model law on enterprise group insolvency. We count on the already established network to further enrich the Uncetral cloud database with the case law related to the model law on cross-border insolvency from the region. That network already helped us to prepare for publications this year the first cloud issue where regional submissions are in Spanish. And we are thankful to the G8 leaders and experts from the region for their contributions to this issue. The last speaker for the first session is Professor Trank, Director of the Institute of the East European Law, Chairman of Center of East European Studies of Kiel University. Professor Trank will present an academy-led project that was launched this year. The Uncetral Secretariat supports the project because of its direct relevance to Uncetral insolvency texts, in particular the 1997 model law. In fact, discussions that have already been held by academics represented in the project have helped the Secretariat to identify developments related to Uncetral insolvency text in various jurisdictions that are represented in this important project. Thank you, Professor Trank, for agreeing to present the project to the Commission. The floor is yours.
Distinguished delegates and observers, first, thank you very much for the friendly introduction and for the honor of being invited to this important and interesting panel discussion. I'm going to give you in the following presentation an overview of the research project on EU cross-border insolvency law and third countries, which ways forward, which has been started in February of this year by a number of scholars from different countries and which we hope to complete next year in 2023. The project is policy-oriented. That is, we try to develop fresh ideas how to further develop cross-border cooperation in insolvency matters in the future. It is basically an academic project. This gives every participant the possibility to express his own personal view. We have no need to find a generally agreed solution, but we can accept, even as an outcome of the project, different views on certain issues. However, we plan to formulate at least some agreed recommendations. Although the project is basically academic, we have invited, and we are very glad to have them in our group, several judges and insolvency practitioners from different jurisdictions. The project came into being in a grassroots manner, merely from experience in teaching and doing research in cross-border insolvency law. Professor Jasnica Garažić from the University of Zagreb, whom you know from work in Antitrust Working Group 5, and me are the coordinators of this project. And we also have an advisory committee, which includes some very well-known academics from different legal backgrounds. The project has received the official endorsement of the Secretary of Uncetral and of the Secretary General of the Hague Conference on Private International Law. And we have also, as from the beginning, established good working contacts with the European Commission. The responsible officer of DG Justice of the Commission is an active observer in our project. What are the links between this project and Uncetral's work? Well, some EU member countries, but by far not all of them, have adopted the model law on cross-border insolvency. And as is well known, the EU has passed its own insolvency regulation. However, as the regulation addresses mostly inner EU relations, insolvency cooperation with non-EU countries is by and large left in the hands of the member states. Some countries have opted for the model law as a basis for cooperation with non-EU countries, while others tend to apply the EU regulation to relations with non-EU countries by analogy. And a third group of countries has no codified approach at all and tends to deny cooperation as a general approach. This can hardly satisfy from the perspective of creditors or even debtors, specifically also in the context of cross-border restructurings. As many insolvent enterprises have business links, subsidiaries, or other property in non-EU countries, there is clearly a need for better, more systematic dealing with global situations. One can imagine different outcomes. For example, the model law, unchanged or with changes, could be used for relations with the EU and non-EU countries. Or the EU insolvency regulation could be extended to relations with third countries, perhaps in some modified form. Or the EU might conclude some treaties covering cross-border insolvency matters with non-EU countries. As such, deliberations cannot lead to workable results without an intensive dialogue with non-EU countries. We have tried to initiate such a dialogue. Of course, Uncetral is the best established institution to organize such a dialogue. However, free academic discussion has its own value and can, at least we hope so, also give some input to Uncetral's work. We are therefore very glad that the Secretary of Uncetral seems to share this view and has chosen to support our project ideally. What are we going to do now and next? Our research group comprises presently about 45 participants from all continents. We are still welcoming new members, in particular from countries which are today not yet represented. I have recently presented the project at the London Congress of Insol International, and some additional participants then joined our group. In our project, we have set a deadline of end October this year for delivering papers, and will then discuss them in the research group and publish them in 2023. Thus, the basic outcome of the project will be a publication. However, we created a continuing process of discussion within the research group and recently carried through a first workshop. Other workshops will follow, and we plan 2 larger conferences for more detailed discussions. Representatives from international organizations are always invited to participate. We are very happy about their participation, and we will discuss with them issues of their interest. So it should be a mutual exchange in order to move and to ideas further. We can easily also organize educational events and would be very glad if Uncetral had an interest in this as well. Thank you very much for your attention.
Thank you. Indeed, the envisaged outcome of the project may inform insolvency law reform in Europe and beyond, and make Uncetral insolvency text increasingly relevant in cross-border insolvency relations between European Union and non-European Union countries. I would like to conclude this session with words of appreciation to the speakers for finding time to share their knowledge and experience with us today, and also time invested for preparing for this panel discussion. This session illustrated different means that are used by the Uncetral Secretariat to identify needs for insolvency law reform, capacity building, and cross-border dialogue. Those means help the Uncetral Secretariat also to promote Uncetral text by raising awareness about them. This leads me to the next session on matching the identified needs with the available resources that will be moderated by another insolvency team member in the Uncetral Secretariat, Benjamin Harrison.
Merci, Samira.
Thank you, Samira. I have the honor to introduce this panel on matching the resources of the Secretariat and the needs of the users of Uncetral texts on insolvency. Everyone is well aware above all, the member states, that the Secretariat's resources are scarce. They need to be used with all due care, namely to ensure the relevance of technical assistance efforts and efforts to spread the text of Uncetral, the efforts by the Secretariat, that is, and also to maximize their impact on their end users. By end users, I'm referring to the states that enact the texts in their domestic law, but also the judges and magistrates that apply them or use them in their everyday practice. First off, we're going to hear from my colleague, Ms. Atta Kominder. She's the head of the Regional Uncetral Center for Asia and the Pacific. She will present some examples, the most recent examples on the use of Uncetral text regarding insolvency in the Asia-Pacific region, which has undergone strong economic growth in recent decades, but also has suffered several economic crises impacting economic stakeholders. Here, the regional center is collaborating with many active institutions as regards the reform of insolvency law. At Tita, you have the floor.
Thank you, Benjamin. Greetings to everyone. The year 2022, in addition to marking MLCBI's 25th anniversary, also marks the 10th anniversary of the Uncetral Regional Center for Asia and the Pacific, or RCAP. Since RCAP's establishment in 2012, Uncetral has expanded accessibility by delivering technical assistance activities in multiple UN and regional languages, with the majority of Asia-Pacific jurisdictions having adopted at least one Uncetral instrument, ranging from e-commerce to dispute resolution and insolvency, furthering legal harmonization and enhancing trade. Uncetral's insolvency instruments are a popular topic for assistance in the region, particularly in the wake of the pandemic. The Regional Center matches this need with available support on several fronts, but for brevity, I will highlight three categories. First, partnerships. Many actors are involved in insolvency law reform in the region, such as the World Bank Group, the Asian Development Bank, or ADB, the European Bank for Reconstruction and Development, and the International Insolvency Institute, Asian Business Law Institute. As such, building partnerships is essential, particularly where the limited resources of Uncetral and our partners are leveraged, and Uncetral insolvency texts promoted by our partners using our guidance materials. For example, this spring, Vietnam officials invited the Secretariat to co-organize a capacity-building workshop on Uncetral cross-border insolvency following recommendations on the matter from ADB. Uncetral thus put together a half-day workshop for interested agencies with some preliminary comparisons of Vietnam's current regime to the Uncetral framework. The Regional Center also collaborates with partners to co-host regional conferences to promote Uncetral insolvency instruments to a broader audience. For example, last November, the Regional Center co-organized with Hong Kong SAR Department of Justice and supported by the ADB, the 4th Uncetral Asia-Pacific Judicial Summit, a biennial flagship event providing capacity building on Uncetral insolvency and other instruments to over 800 judges, officials, practitioners, and academics, ranging from Armenia and Bangladesh to Nepal and Papua New Guinea, among others. Last year's edition interestingly discussed the new cooperation mechanism on corporate insolvency and debt restructuring put in place by Hong Kong SAR Department of Justice and the Supreme People's Court of China, allowing liquidators from Hong Kong to apply to mainland courts for recognition of insolvency proceedings in Hong Kong SAR and vice versa. According to official sources, the mechanism references certain principles in the MLCBI and actually goes beyond the model law to accommodate specific jurisdictional needs. That the MLCBI can be used as a flexible basis is precisely what it is designed to accomplish. Last September, the Regional Center also co-hosted the Incheon Law and Business Forum with the Korean Ministry of Justice. One panel focused on the new Uncetral legislative recommendations on insolvency of micro and small enterprises. The event garnered over 430 stakeholders from government, business, and legal sectors from 72 jurisdictions across the Asia-Pacific and beyond. The second way by which the Regional Center matches needs with available support is by reflecting in the program's sub-regional integration dynamics and the location of major restructuring and insolvency hubs in the region. The role of those factors in domestic and cross-border insolvency law reform across the region cannot be underestimated. In our experience, the enactment of an Uncetral text in one country in the group of countries sharing the same cultural and historical roots, legal traditions, similar language and level and model of economic development produces the domino effect on other countries in the same group. The third and final way highlights how the regional center works with jurisdictions to address individual needs and requests. For example, in India, RCAP has been working with experts and institutions such as the Uncetral National Coordination Committee, the Insolvency and Bankruptcy Board of India, and law universities such as GNLU and NLUD for several years to promote Uncetral insolvency instruments. Key activities include co-organizing regional conferences for public stakeholders and insolvency moots and lectures under the Uncetral Asia Pacific Day flagship academic series. We believe this has helped foster awareness of instruments such as the MLCBI, which in a recent case appeared to be read into the Insolvency Code framework by the National Company Law Appellate Tribunal, and is also part of India's most recent package of measures for insolvency law reform. My last two examples are Thailand and Mongolia. Upon request, the Regional Center initiated a series of meetings with Thai agencies to discuss developments on their use of Uncetral instruments, including insolvency. This provided line agencies the opportunity to update the Secretariat on how recommendations of the Uncetral Legislative Guide on Insolvency Law, including the recently added Part 5 on insolvency of micro and small enterprises, were applied in recent domestic reforms. In response to the outlined concerns, in particular as regards cross-border insolvency aspects, the Uncetral Secretariat brainstormed the way forward with interested agencies, including further support needed to enhance understanding among local policymakers, judges, and other practitioners of Uncetral model laws in the area of insolvency, the experience with their use across the globe, and benefits of enactment in Thailand. Mongolia, as other landlocked developing countries in the region, faces specific needs in legal reform. Last December, the Uncetral Secretariat was invited to present on the Uncetral legislative recommendations on insolvency of micro and small enterprises at a conference hosted by the Ministry of Justice and Home Affairs of Mongolia. The conference addressed practical challenges and obstacles to implementing private law reform in that jurisdiction and was the occasion to present best practices from different jurisdictions and international organizations. The observations made during the conference were to be included in the package of law reform recommendations made to the government. With that, I end my presentation. Thank you.
Je vous remercie, Atita.
Thank you, Atita. We're now going to hear from two seasoned judges. They're recently retired. They're involved in training, in raising awareness, and sharing and exchanging experience with judges all over the world. Ms. Nicoletta Nastasi, you had a career as an attorney, and afterward you served 18 years as a judge specialized in addressing the difficulties of businesses in Romania, which is a civil law country. In that capacity, you participated in many initiatives to promote cooperation, communication, and coordination among courts in the context of insolvency, under the auspices of Uncetral, of course, but also the EU, INSOL, and the International Insolvency Institute. This is the topic of a thesis that you're currently preparing at the University Tito Maiorescu in Bucharest. What lessons would you draw from this training and information work? And how is it possible to improve the impact of the initiatives among the judges on the ground, especially in civil law jurisdictions?
Thank you. Thank you, Benjamin. I feel very privileged and honored to be given this opportunity to address the 15th session of Uncetral on this panel. And in this address, I would like to share my views as a European civil law judge specialized in insolvency law on some of the difficulties for judicial activity and cross-border cooperation. I will go on to acknowledge the important role of Uncetral training programs and mechanisms as main drivers for a more international view in insolvency matters. And finally, I will express my thoughts on some prospects for the future. And I begin with a fundamental observation. Full harmonization of insolvency law, unification, or even approximation does not seal a real possibility, because such unity of vision to be achieved requires significant amount of ideological and practical compromise and substantive legal convergence, and is difficult to obtain because national legal systems and domestic policies are far too different. But in the context of the international evolution towards a functional jurisdiction, the essential aspects of the judicial system are the specialization of judges, speed and fairness of judgment, predictable application of substantive and procedural law, part of the general trend towards internationalization of the judiciary. Businesses are becoming globally interconnected, and this present day reality brings to judges new perspectives but major challenges. And I don't believe there are real boundaries between the judiciary in civil law system and common law jurisdictions in the insolvency field. Therefore, effective cooperation is not only necessary but also possible, and judges should act creatively to develop it. In my PhD research on cooperation communication in cross-border insolvency cases, one of the questions was how to promote Uncetral soft law instruments in a practical way, taking into account the specificity of national legal system and practices. And first, the Uncetral World Bank Group Judicial Capacity Building Initiative on International Best Practices started in 2021. It's a relevant project for members of the judiciary around the world, because judicial training is essential for developing expertise for complex and international cases. At the same time, judges should meet with their counterparts in other jurisdictions whenever possible to change professional experience and practical insights. And these skills are developed within the Uncetral Judicial Training Program. The plenary session, through the topics established for debates, focuses on solutions useful in daily judicial activity. The other two sections, discussions among participants based on a case study and discussion in plenary among all participants, provides an excellent opportunity to heighten international communication and cooperation among participants. And as a civil law judge with the experience of more than 40 international training programs, I can say that this project is special because it brings together and enables communication between judges from common law and civil law systems, allowing them to share experience about national legislation, procedural acts, practical difficulties as a basis for future collaboration. Judges can get to know each other, and in this respect, the program can be a mechanism for creating an online international platform for direct judicial communication, developing a network of judges specialized in insolvency matters. Secondly, the first edition of the Digest of Case Law on the Uncetral Model Law of Cross-Border Insolvency 2021 and the Judicial Perspective updated this year promote uniformity in the application of MLCBI. As such, they may be helpful in particular to judges from civil law jurisdictions who, for various reasons, might have had limited exposure to complex cross-border insolvency cases. And in the absence of domestic cases and guidelines, civil law courts may look for assistance in the practice of foreign courts. The Digest and Judicial Perspective are important sources of information for their judicial activity. Both publications build on the MLCBI-related case law collected in the case law and Uncetral text cloud, assist judges by making available decisions of courts and arbitral tribunals interpreting Uncetral text. But while the Digest systematizes the case law per article of MLCBI, the Judicial Perspective takes a more practical approach. And what does pragmatism mean for the judiciary? I am thinking of a judge who considers each case on its individuality, who is flexible and creative in managing insolvency cases and judicial decisions. On the other hand, the judiciary's role is not limited to the adjudication of pending litigations. In appropriate circumstances, such as where the meaning and effects of existing laws are unclear or laws are in conflict, it may be open to the judiciary to act as lawmakers. And in this respect, judges may find authority in Uncetral model laws and judicial guidance materials that reflect international best practice. Some prospects for the future. In practice, bringing the Uncetral texts in everyday judicial work is a difficult task because they are not translated into the languages of different states. And this is an area where Uncetral assistance is particularly needed. I believe that the Uncetral model laws and implementation guides should be translated in national languages in different jurisdictions, accessible online for all interested parties, practitioners, and judges. As far as the European Union is concerned, I believe that it's possible in collaboration with the European Commission to translate at least some of the Uncetral texts and make them available to the public in the EU member states. And in this way, they can be promoted more easily to the national authorities, as in the case of Romanian judges, the Ministry of Justice or National Institute of Magistracy. And this process may be also a further step for the European legislators to consider the possibility of harmonizing Uncetral proposals with the EU regulation on insolvency proceedings. And let me conclude with the observation that Uncetral's activities are essential for judicial work in insolvency law worldwide, encouraging judges to engage and to actively build a culture of trust and predictability for insolvency law. And I convey my respect and best wishes to each of you. Thank you, Benjamin.
Je vous remercie. Merci beaucoup.
Thank you very much for that presentation. I'll now turn to our third and last speaker, Sir Alistair Norris. You also served as a judge for 18 years in a common law country, namely the UK. Over these 18 years, you encountered a great deal of litigation linked to international insolvency. You also chaired the Committee on the Rules of Procedure for Insolvency at the High Court. You were involved in many efforts to provide training and to raise awareness among your magistrate colleagues all over the world. And yet, beyond the adoption of uniform rules on insolvency, the challenge is to create an ecosystem, namely to allow judges to specifically apply Uncetral law to the cases that fall to them. How can this ecosystem be generated?
It is a privilege to be able to speak directly to you today. I intend to speak briefly of my own experience. The key Uncetral documents, such as the Model Law on Cross-Border Insolvency of 1997 itself, and the Guide to the Enactment and Interpretation of the Model Law of 2013, are addressed primarily to policymakers and legislators. They seek to secure the adoption of a global framework. The preamble to the Model Law itself says that amongst its objectives is greater legal certainty for trade and investment. Certainty means predictability of outcome. At a recent conference I attended, a poll of delegates demonstrated that 46.67% of the attendees thought that a track record of successful reorganization was the most significant factor in the choice of jurisdiction and law. Predictability of outcome requires a uniform interpretation and a uniform implementation of the relevant law. As one speaker at the conference said, only having the law does not bring you to having a commercial and creative legal system. Another speaker said, you need an ecosystem, not a law. Uncetral seeks to create such an ecosystem, supporting its recommended law in 4 ways. The first way of developing an ecosystem is by ensuring that judges really understand the law. This is the program of judicial capacity building. The model law is often introduced in the context of wholesale modernization of the domestic insolvency law. It is vital that judges are introduced to and enabled to understand the whole of this new structure. This capacity building work is often undertaken in partnership with other organizations. I've recently been involved in judicial training in India, Malawi, Mauritius, Zambia, and the Eastern Caribbean. Of course, in the past 2 years, this teaching has had to be done on a digital platform, which both shortens the training courses and limits engagement. But such training is still valued. Attendees are taken from basic insolvency concepts through the practical application of those concepts in case studies and discussion scenarios analyzed by both lawyers and accountants, and then onto the model law itself. One of the most fruitful techniques is role play, where groups of judges assume the role of individual interested parties to gain insight into what the interests of that group are and how they are affected by the insolvency or restructuring process. Of course, that is technically difficult to achieve digitally. The second way of creating an ecosystem is by making accumulated knowledge accessible to working judges, both in relation to the interpretation of the model law and in relation to its practice and supporting procedures. Here, Uncetral provides 2 useful tools. The first tool is the legal database of relevant cases, Case Law on Uncetral Texts, or CLOUT. This largely depends upon individual judges offering judgments for inclusion. So this year, I uploaded what I thought might be a useful model recognition judgment designed to demonstrate that in a straightforward case, it is possible to give reasons for a recognition decision without writing a doctoral thesis. One consequence of this is that the database has grown in an unstructured way, but it has now been supplemented by the digest of case law on the model law, published in 21-22, which Judge Nastasi has already mentioned. And I anticipate that this will afford improved access. The second tool is the very recently updated Judicial Perspective, a book written by judges for judges and containing both analysis of legal issues and advice on practical issues. It is certainly used in England and Wales, the United States, and Singapore as an aid to decisions. I have this year been involved with other judges in updating it by reviewing UK and European cases. The third way of creating an ecosystem is by sharing experiences together face to face. We have just finished the Judicial Roundtable held in London and co-sponsored by Uncetral. In year 1, the colloquium is by invitation only and does a deep dive into complex issues encountered by judges who are highly involved in insolvency and restructuring work. 2022 was such a colloquium. 30 judges discussed issues of fairness in restructuring, group insolvencies, noting both the recent EU recast law and the Uncetral model law on enterprise group insolvency, recognition under private international law in non-model law jurisdictions, and cryptocurrencies, and overlap with an Uncetral working group. It was especially pleasing that many judges from civil law jurisdictions accepted invitations and took a prominent part in discussion. The next colloquium will be an open one, considering more basic and common issues and attended by a much larger number and broader cross-section of judges. The fourth means of creating an ecosystem to implement the law is by examining specific issues together. October 2021 saw the first Uncetral World Bank Judicial Workshop. Jas Nastasi has already referred to this, and it was a pleasure to work with her. The workshop concerned setting aside pre-insolvency dealings in order to increase the size of the estate that is distributable between creditors. On the 27th of October, we led in discussion approximately 120 participants from across Africa, Asia, and the Pacific region, and on the following day, slightly fewer from the rest of the world. It was pleasing to have a large attendance from North African and Middle Eastern jurisdictions to bring an Islamic perspective to our discussions. Those are the four ways that Uncetral seeks to achieve predictability within and across jurisdictions. I'm very grateful for the opportunity to participate in each of these programs. I thank you.
Merci beaucoup.
Thank you very much. Without further ado, I wish to thank our three panelists who agreed to share their experience with us today. Thanks to the commitment of these professionals and these partner organizations, the texts of Uncetral have found practical application and have become useful in everyday life. I need to say that personally, I draw great satisfaction from seeing the work of the Secretariat on the preparation of texts at the working group lead to the practical implementation of the recommendations adopted by Uncetral. I thank you again for your attention, and I give the floor to my colleague, Caroline Nicolas, for the third and final panel this morning. Thank you.
Thank you very much, Benjamin. Good morning, good afternoon to everybody. For our final panel this afternoon, or session, we're going to talk about the lessons that we have learned from this experience sharing, and we're going to hear from two people very well qualified to talk about learning lessons. And the first is Ms. Samali Kingi, who is the General Counsel of the Afrexim Bank. And the second is my colleague, José Angelo Estrefalia, who is the Principal Legal Officer and the head of the legislative branch of the Uncetral Secretariat. But before I pass the floor to them, I thought it might just be helpful in my guise as the head of the technical assistance section of the Uncetral Secretariat to just give you a few thoughts of mine, having listened to two excellent sessions and some very interesting speakers. And I hope that you will forgive me for being a little bit disjointed, because I have simply taken some notes as we have talked, and they will be obviously a little bit less polished than my colleagues have been. The first thing I heard, which I think is absolutely critical, is just how important insolvency regimes are. It's often thought that it's a bit of a niche area, but what we've heard from particularly the World Bank Group, the IMF, Ebrd, and also recently our judge speakers, is just how important this issue is, not only in terms of economic climate more generally, which, as we know, is extremely challenging, but also more precisely about the macroeconomic impact of having good insolvency regimes, questions of debt burden, and generally supporting economic growth. And I think that's a very important lesson from the insolvency perspective. But just to highlight too, that all of Uncetral's texts, although they're private law dominated, are intended to have a good economic impact. The second lesson that I think that we've heard this afternoon, which I think is absolutely critical, is the use of Uncetral texts in practice. Now, we all know that harmonization of international commercial law or international trade law in the Uncetral context is not just issuing very good, even if they are very good, technical texts. They need to be used. They need to be used in practice, that is enacted and then used in commercial transactions. And also, as we've just heard, uniformly or as close to uniformly as possible interpreted. And here, this raises several questions of coordination. So it's really useful to hear and very gratifying to hear of the various agencies that are using the Uncetral insolvency texts in, for example, the ICR standard and so forth, and the Ebrd in their benchmarks, which are aligned with international standards, including ours, when looking at national restructuring laws and national insolvency laws and in market practices. That's a very important thing because a practical aspect of harmonization is that countries receive consistent and coherent advice from international and donor agencies. And as many of us involved today will know, this has not always been the case. And it's great to see how much progress has been made here. And not just from what we heard as the top-down approach, but also through what was described as more grassroots approaches. So the G8 program and the academic research project in the policy context we heard about from Professor Trunk, they both emphasize the importance of learning across borders in countries with some similarity in experience, but or they will have differences, as we heard, through in-depth sharing of experiences, being led by international and national experts, but really involving policymakers, experts, academics, and those at the coalface of insolvency, if I can call that. And it's only by sharing that level of experience, all those different perspectives, that we will get what we want in Uncetral, which is the context of practice to policy to legal reform, because that's really how you make things sustainable and effective. So I think that was a really important lesson that I saw through these two sessions. One of the other things that was particularly brought out in the second session was the question of coordination and leveraging our always limited resources. Each agency or each person spoken here has an important role, but in the grand scheme of things, everybody is relatively small. And so our need for coordination is extremely important. We've heard too about how the interest in Asia has been coordinated through our regional centre and how important leveraging both sub-regional dynamics and regional groupings can be to make that more effective and more sustainable. And in fact, as member states taking part today will be aware, that we in the Secretariat have reported to the Commission in our reports in our technical assistance and cooperation activities that working through partnerships is demonstrably more efficient, more effective, and more sustainable in terms of outcomes than the Secretariat has been able to achieve alone. And we now do most of our activities in this area through such partnerships. I might add to the experience that's been shared today that OHADA, that's the Organisation for the Harmonisation of Business Law in Africa, has used the Uncetral's recommendations in the Legislative Guide on Insolvency Law and the Model Law on Cross-Border Insolvency in its own uniform act. And since it has 17 member states, we can see how these regional initiatives can really support the enhancement of Uncetral's effectiveness on the ground. Just turning for a moment to the concept of judicial cooperation and capacity building, I think the points that were made in our second panel really do bear highlighting. The need for capacity building and cross-border exchange among lawyers is so important. We as lawyers all come to this environment with our own national system as a training background. And that obviously means that we have to communicate and understand and collaborate and role play and all those useful things that our last speaker, Judge Alistair Norris, highlighted. And this is so important because we've seen in Uncetral legislative development work that misunderstandings because of terms used differently in different systems are really very significant in some cases. And the capacity building, the cooperation is so important, but Uncetral's role here, as was highlighted, is to issue clout cases and texts like the Judicial Perspective and the Digested Case Law. And I'm really pleased to hear that the partners in G8 will help contribute to clout, that judges will help contribute to clout, because it is such an important aspect for us, because it's a multilingual resource, and that is very, very unusual in terms of legal databases. And I'm particularly pleased to note for everybody's benefit that we have Uncetral days in Asia Pacific, Latin America and the Caribbean, and for the first time this year in Africa, in which we are really encouraging universities and institutions of higher academic learning to help us in rejuvenating and broadening clout. And just finally, before I hand over to our final panelists, I just want to talk a little bit about connections, because the other final thing I heard today is the importance of connections, not just between the different national and cross-border concepts of insolvency, but also between insolvency and non-insolvency texts, the importance of secured transactions, and making connections among ourselves, the importance of the cross-country, cross-border, cross-system connections to help us understand each other, I think is so important. I really welcome the examples that we've heard from Romania, United Kingdom, as well as our other panelists from international and non-international systems. And it gives me great incentive to seek to replicate this multilingual cross-continent experience that we've heard about today, not just in insolvency, but in the other Uncetral subject areas. And it's great to hear that the G8 are brainstorming about pushing this further. Indeed, looking at other language systems outside just the UN6. I know there's an initiative for Portuguese-speaking countries and so on. And I think the point made, I think it was by Judge Nastasi, the importance of having materials in national languages is so important. Clearly, it's beyond the resources of us in Uncetral, and I suspect everybody around this table to be able to do that individually, but encouraging others to do that, I think, is very important. So I'd like, from my side, and as somebody who's not involved in the legislative development in Uncetral, but as leading our technical assistance activities, I'd like to thank everybody for really putting over some excellent points that have given me a lot of food for thought, and that I will certainly be helping Uncetral to build into its technical assistance programs. So that, I think, is enough from me for now. And what I'd like to do now is to hand over to our first panelist, who is Ms. Samali Kingi, and I'm sorry for the pronunciation, I'm sure I haven't got that right, who is the General Counsel of Afreximbank. She has a long career also in other banking institutions in Australia, the UK, and Africa. And she's going to talk to us about learning across regions in the free trade and economic integration contexts, which is a further expansion of our considerations this afternoon. Ms. Kingi, the floor is yours, and thank you very much for being with us.
Good day. It's a pleasure to be here, and thank you again to Uncetral for the very kind invitation. I'm the General Counsel of the African Export-Import Bank, which is a multilateral development bank established by African governments to support trade and development. We currently have 51 African member states. My talk today will focus on the state of insolvency reform in Africa. Africa is a diverse continent of 55 countries, so it is difficult to generalize. However, I will endeavor to touch on some key themes at a very high level. However, before I get to Africa specifically, it is important to note that insolvency reform, as a general matter, is not an easy issue. And as we mark the 25th anniversary of the adoption of the Uncetral model law on cross-border insolvency, we must recognize the incredible contribution that the model law has had in this often challenging area. Insolvency reform tends to be born out of financial crisis or market integration. In fact, the harmonization of such norms globally didn't actually begin until the 1990s, a decade where we saw the rapid rise of globalization, as well as the Asian financial crisis. This combination of more connected markets and the occurrence of economic upheaval is a potential recipe for financial instability at both national and international levels. Creating a framework to achieve more efficient, cost-effective, cross-border insolvency processes is seen as a means of mitigating this risk. In this context, Africa makes an interesting case study. Out of the 51 states which have adopted the Uncetral model law globally, a total of 25, almost half, are in Africa. This is interesting because when we talk of globally integrated markets as a driver for insolvency reform, Africa is actually the only continent that trades the least with itself. The significant uptake of the model law in Africa can instead be attributed to the innovative approach taken by 17 mostly Francophone countries in West Africa who created OHADA, which is an acronym in French for the Organization for the Harmonization of Commercial Law in Africa. In 2015, OHADA implemented a uniform insolvency law, which replaced the legislation previously in force in its member states. The OHADA approach enacts uniform laws in the domestic legal systems of its member states. This approach is predicated on first creating new insolvency procedures for all jurisdictions concerned, and then dealing with cross-border issues. Significantly, the OHADA Uniform Law on Insolvency adopts the Uncetral model law. While the member states of the OHADA region generally share a common language, French, and their legal systems tend to have similar historical roots, this is not the rule across the board, and membership is open to other African countries. The organization therefore represents a useful model of what can be done in the law reform space where there is the political will. The inroads made by OHADA in the adoption of the model law are very relevant in the context of the African Continental Free Trade Area. The African Continental Free Trade Area is an historic Pan-African agreement which will eliminate tariffs and other barriers, creating the world's largest free trade area with a market of over 1 billion people. There are high hopes for implementation, and its success will be critical to the building of a more prosperous Africa. Greater intra-Africa trade will lead to more economic integration and greater cross-border activity. Successful implementation of the free trade area will therefore be greatly enhanced by a harmonized approach to cross-border insolvency and business reorganization. As mentioned previously, Africa has a good record in terms of adopting the Uncetral model law. However, a key challenge to further adoption and also to wider insolvency legal reform is the stigma often associated with insolvency. Regional integration in and of itself does not automatically translate into a harmonized approach to cross-border insolvency. This can be seen in the case of the East African Community. Established in 1967, it's one of Africa's oldest economic blocs and currently has 7 members. The East African Community has a regional parliament which regularly earmarks sectors for review and harmonization. for example, immigration law, customs law, banking law, etc. Insolvency law is notably absent, and this is in large part due to the stigma often attached to insolvency. Insolvency is often equated to liquidation, and in many African jurisdictions, the concept of using insolvency for corporate rescue is not common. As a result, many insolvency regimes, cross-border or otherwise, are only used when a corporate is no longer viable and there is absolutely no alternative. Many stakeholders prefer litigation and enforcement to insolvency processes. Conversations around the benefits of a robust insolvency framework are also hampered by the fact that there are very few examples of corporates that have emerged from an insolvency process intact. The examples that come to mind are South African Airways, Kenya Airways, and Arik Air in Nigeria, all of which are airlines, all of which were seen as being strategically important, and all of which had substantial government support. The good thing about these examples is that they demonstrate a growing sophistication around how to deal with corporates in distress. They are, however, unfortunately isolated examples. More needs to be done to address the stigma around insolvency and to demonstrate how the process can potentially unlock value in corporates, regardless of their size or level of government support. The African Continental Free Trade Agreement, however, presents a timely opportunity to reframe the conversation regarding insolvency and business reorganization and position such discussions within the context of African economic development generally. In conclusion, Africa presents a unique example of a continent determined to move towards greater economic integration on a macro level through the creation of the African Continental Free Trade Area. Greater economic integration, however, does not automatically translate into the creation of better insolvency systems. However, as demonstrated by the Ohara region, change is possible, provided that there is the political will. And as a Pan-African development institution, we hope to work together with Uncetral, governments, and other DFIs to work towards this goal. Thank you.
Thank you very much, Ms. Kiengi. I think that was a very, very interesting perspective, and two things that really jumped out from me there were the concept of the stigma involved in insolvency, and I think that's a very timely reminder to us. I think it was Judge Norris was also talking about this, that insolvency is not just about the lawyers, it's about the ultimate businesses, other groups who are involved like accountants, and very importantly, the concept of political will, because it is in many ways a political question. And the other point that I thought was very, very interesting is the concept of success stories. And I think in the donor environment, we're often asked, well, there are costs involved in law reform, and we don't generally have good empirical evidence of what the benefits are. And perhaps some of these success stories showing that there can be good results will help us encourage countries to go through the investment process in law reform for the benefit of their citizens and through their corporates. So thank you very much for giving us some excellent food for thought. I'd now like to turn to our final speaker today, my colleague and the head of the legislative branch of Uncetral's Secretariat, Mr. José Angelo Estrella Faria. Angelo, the floor is yours. You're going to talk to us about more closely linking legislative and non-legislative work. Thank you.
Thank you very much, Caroline, and good morning, good afternoon, and good evening to all the participants. I believe we all agree that the preceding speakers have given us an excellent insights about tools used for assessing the needs for insolvency law reform and the resources and capacity building that are required to meet them. I would now like to share with you a few thoughts on the link between the process of formulating legal standards and implementation through non-legislative activities. As one would expect, Uncetral texts are the basis for Uncetral non-legislative activities. This makes it important to engage partners of Uncetral in its non-legislative activities already at the legislative stage, so as to secure their engagement and commitment to the standards reflected in Uncetral texts, build their knowledge of Uncetral texts, and raise their understanding of the intergovernmental rulemaking process, the compromises it involves, the choices eventually made in each project, and the reasons therefore. Such knowledge has in fact proved to be useful and indeed necessary at all stages and in different types of technical cooperation and non-legislative activities. For instance, it is necessary in preparing tools for legal diagnosis of the legal environment for insolvency, such as those that are used by international financial institutions, where Uncetral insolvency texts have served as a benchmark for assessing financial sector insolvency and creditor rights or debt restructuring frameworks. We heard examples from the World Bank Group, IMF, and Ebrd. Such knowledge is also needed for identifying also gaps and needs in insolvency law reform around the globe. For example, G8, an initiative which Andrei Rocha has described earlier today and which the Uncetral Secretariat actively supports, used the Uncetral Legislative Guide on Insolvency Law and the Model Law on Cross-Border Insolvency in its program that helped identify needs in local capacity building. Knowledge of Uncetral texts is also crucial in designing and implementing activities. For example, the Asian Development Bank uses the Model Law on Cross-Border Insolvency and the Guide to Enactment in its insolvency reform activities. The Model Law on Cross-Border Insolvency is also using bilateral aid programs, for example, by the U.S. Commercial Law Development Program of the Department of Commerce of the United States, which most recently in the Gulf countries resulted in the enactment of the Model Law on Cross-Border Insolvency in Bahrain, Jordan, Morocco, the Dubai International Financial Center within the United Arab Emirates, and is expected to result in enactment in Saudi Arabia. And finally, knowledge of Uncetral texts is useful for monitoring, evaluating, and planning future activities. For example, we heard from Ebrd as a plan to expand assessment indicators for cross-border insolvency and MSAE insolvency on the basis of Uncetral texts. As a result of their early engagement in Uncetral legislative activities in the process of formulating legal standards, the Uncetral partners acquire first-hand knowledge and are ready on day one to provide technical assistance on the basis of Uncetral text. And this ensures efficient use of limited resources, both within the Uncetral Secretariat and its partners, and also the delivery of consistent messages to recipients, which in turn prevents conflicting outcomes in legislative acts enacted at domestic level. The outcomes of non-legislative activities in turn inform the future legislative program of Uncetral. For example, the Judicial Capacity Colloquium, about which Judge Norris spoke, led to Uncetral's work on the Practice Guide on Cross-Border Cooperation and on the Judicial Perspective, and updates to which the Commission has approved at this session. The academic project of Professors Jasna Garacic and Trunk may inform future legislative work of Uncetral in this era as well. Uncetral legislative texts with guidance materials are being available in the 6 UN official languages, are readily available resources that could and should be used in insolvency law reform and capacity building activities. Besides the practice guide and judicial perspective, they include the guides to enactment and of the model laws, often cited by judges in their judgments, case law related to the model law on cross-border insolvency, compiled and published in the cloud database, the 2021 digest on that model law, also available in the 6 languages, and the guidance note on the enactment of the 3 Uncetral model laws in the era of insolvency law, and the consolidated text of these model laws, the purpose of which is to demonstrate to policymakers and legislators how those model laws could be enacted together, or the latest 2 in addition to the 1997 text. Let me share with you a few thoughts about cloud, since it is a program of Uncetral that lies somewhere between legislative and non-legislative activities. There was a call in the working group when it approved the update to the judicial perspective this April to expand the geographical spectrum of case law abstracts on the model law on cross-border insolvency. As we know, the cloud system relies on a network of national correspondents. This year is a transition year. New national correspondents may be appointed or old may continue. And I'd like to take this opportunity to thank the outgoing national correspondents and welcome new national correspondents on the model law on cross-border insolvency. Ideally, all states that enacted the model law should nominate correspondents who then actively monitor case law and prepare abstracts. Without a national correspondent, it is difficult to ensure diversification of case law. In that context, I also like to acknowledge the contribution of the G8 to fill in gaps as regards the model law on cross-border insolvency related to the 4 enacting states of that model law in Latin America: Brazil, Chile, Colombia, and Mexico. For example, in the case of Mexico, which was one of the first countries to enact the model law, there is hardly any case law that has been reported to the cloud because of language barriers. The G8 program has helped to address this shortcoming. As you can see, the link between rulemaking and technical assistance has many facets, and one program complements and supports the other. The Uncetral Secretariat is at the center of creating that link, but its work is facilitated by others, including state delegates to Working Group 5. For example, we are grateful to the former and present delegates of Italy, France, Mexico, Spain, and Switzerland to Working Group 5, as well as to observers to that working group from invited NGOs, who responded to our call to join the G8 program and contribute to sessions in their native languages and convey Uncetral perspective on issues that are discussed both in the domestic and the cross-border insolvency context. In my conclusion, I would like to stress the crucial role of technical assistance for the dissemination and implementation of Uncetral texts. As we all know, without actual enactment of those texts, the efforts of the international community in preparing them would be wasted. Thank you very much.
Thank you very much, Angelo, for in fact bringing together quite a lot of the points that our earlier speakers have made, and I think bringing this event to a very interesting conclusion. I think the point that you make about the links between the various pillars of our work and the key importance of active participation to allow us to develop excellent texts based on good practice, and then to implement and interpret them, really sums up what we have learned this afternoon. And so I'm very grateful on behalf of the technical assistance section of the Uncetral Secretariat to thank you for making them and emphasizing some of the points that our previous speakers have made, and particularly the importance of insolvency reforms in the free trade agreement and the cross or pan-regional context, as the previous speaker also emphasized. I see that we are very much approaching the end of our time. So with that, I would like to conclude session 3 of this panel and hand the floor over to the Secretary of Uncetral, Anna Joubin-Prete, for some concluding remarks. Thank you very much, Anna. The floor is yours.
Thank you very much, Caroline. Thank you, colleagues from Vienna who have been organizing and running us so smoothly through this last program of our Commission session. Mr. Chair, on behalf of the Uncetral Secretariat, I would like to express our gratitude to all the partners that have engaged with us in Uncetral's non-legislative activities throughout the years since the Commission's 54th session. As we have heard, the work of Uncetral is very much hinges and depends on its the active and efficient and harmonized implementation and interpretation of its text. And of course, the 2 hours we have just spent together on the model law on cross-border insolvency are not sufficient to explore all those issues, but the panel did a great job in showcasing main activities that took place throughout the year towards the promotion of Uncetral's insolvency texts. I would like to invite you to join me in a round of applause for our speakers and organizers. The issues raised by the panel should be subject to more detailed discussion in other fora, including during the various events that we are planning this year for the commemoration of the 25th anniversary of the model law on cross-border insolvency. Let me please inform the Commission that the Working Group 5 is planning to hold during the morning meeting of the last day of its 61st session on 16 December a commemorative event of its own, and such event will build on the outcomes of this panel and go deeper into some issues with the aim of increasing understanding of the model law on cross-border insolvency among practitioners and the relevance of the text in various contexts, from small liquidation cases with cross-border elements that raise risks of dissipation of assets to large-scale reorganization of multinationals. Such an event will undoubtedly be linked to the current work program of Working Group 5, since both projects on asset tracing and recovery and on applicable law intend to supplement the cross-border insolvency architecture created by the model law on cross-border insolvency and 2 subsequent Uncetral insolvency model laws. So on our part, the Secretariat will be in a position to bring the outcomes of this panel to the attention of the working group in a working paper and explore them further on different occasions, including during the Uncetral Days for Africa, Asia, and the Latin America and the Caribbean Days, and in the context of activities planned with our partners in the area of insolvency law in the next cycle. With that suggestion that this information to the Commission, I would like to conclude my remarks, Mr. Chair, and pass the floor back to you. Thank you very much.
I thank you, distinguished delegates of members and observer states, as well as international organizations. We are coming to the close of the 55th session of Uncetral. I thank you for your active engagement and for making the 55th session a success. Despite difficult international environment, including challenges related to climate change, COVID-19, as well as aggression on Ukraine and their negative consequences, including on global trade, we achieved a lot. I'm happy to see the impressive spirit of cooperation and compromise which animates all Uncetral sessions and endeavors. I would like to sincerely express my appreciation and thanks for your meaningful engagement and unwavering support in successfully concluding the Commission's session. It raises optimism in these difficult times. I would like to thank our Vice Chair, Ms. Beate Czerwenka, for chairing the Commission's deliberations under Agenda Items 4, and the Chairperson of the Committee of the Whole, Ms. Giusella Finocchiaro, for chairing the deliberation within the Committee of the Whole under Agenda Item 6. Finally, I would like to thank the staff of the Uncetral Secretariat, especially our distinguished Secretary Anna, Angelo, and Nicola, who helped me chairing this session, as well as the UN Conference Management Services, translators, and interpreters who have worked tirelessly and professionally to make this session a great success. The session is now closed. I wish you a relaxing weekend and joyful summer holidays. Let us charge our batteries. There is a lot to do starting this autumn. I thank you.